Hello everyone. Today we will gain some basic knowledge regarding the Sales of Goods Act through some basic multiple choice questions. So without wasting any time, let's start with it. The first question is consideration for a sale of goods must be by options are A goods in return, B called agreement, C money called price, or D none of the above. The correct answer to this question is option C, that is consideration for a sale of goods must by money called price. The next question is Goodwill, trademark, patent, gas, and water are considered as which of the following? Options are A. Immovable properties, B. Immovable goods, C. Goods, or D. None of the above. The correct answer to this question is option C. The above mentioned are considered as goods. The next question is a contract of sale must have all the essentials of A. Voidable contract, B. Valid contract, C. Void contract, or D. None of the above. The correct answer to this question is option B. That is, a contract of sale must have all the essentials of a valid contract. The next question is a contract of sale in nature is called A. Executed contract, B. Executory contract, C. Quasi contract, or D. None of the above. The correct answer to this question is option A. That is, a contract of a sale in nature is called executed contract. Next question is Majid engaged Asif, an artist, to paint a portrait and supplied the canvas and paint. It is a contract of what nature? Options are A. Specified work, B. Sale, C. Agreement to sell, or D. None of the above. The correct answer to this question is option A. That is, this is an example of specified work. Next question is Shafiq, a dentist, agreed to make a set of artificial teeth to fit the mouth of a customer. The contract was A. Specified work, B. Sale of goods, C. Agreement to sell, or D. None of the above. The correct answer to this question is option B. The contract was an example of sale of goods. The next question is Stipulation collateral to main purpose of contract is called A. Warranty, B. Guarantee, C. Condition, or D. None of the above. The correct answer to this question is option A. That is, stipulation collateral to the main purpose of the contract is called warranty. Rohan purchased a car from Mohan. The car turned out to be a stolen property and Rohan had to restore it to the turn owner. The options are Rohan cannot recover the price paid to Mohan. B. Rohan can recover the price paid to Rohan. Mohan is not liable to Rohan. And D. None of the above. The correct answer to this question is option B. That means to say, in this situation, Rohan can recover the price paid to Mohan. Majid, a buyer, faced the problem of distribution of possessing goods. In this case, Majid A. may recover compensation, B. cannot recover compensation, C. both A and B, or D. none of the above. The correct answer to this question is option A. That is, in this case, the margin may recover compensation. Next question is Nazir, a dairyman, supplied milk to Imran. It was contaminated by germs of gever. Imran's wife was infected and died of it. In this case, options are A. Nazir will be held liable in damages. B. Nazir will not be held liable in damages. C. Imran is liable himself. D. None of the above. The correct answer to this question is option A. That is, Nazir will be held liable for paying up the damages. The next question is, which of the following does not fall in the category of goods? Options are A. Stocks and shares. B. Money and actionable claims. C. Growing crops and grass. Or D. Things attached to or forming the part of land which are agreed to be severed before sale or under the contract of sale. The correct answer to this question is option A, that is, stocks and shares does not fall in the category of goods under the Sales of Goods Act 1930. The next question is, where there is a contract for the sale of specific or certain goods, the property in them is transferred to the buyer at the time when the A. Parties intend the properties in goods to pass. B. Contract is entered into. C. Price is paid. Or D. Delivery of goods has been made. The correct answer to this question is option D. That means to say where there is a contract for sale of specific or a certain goods, the property in them is transferred to the buyer at the time when the delivery of goods has been ascertained. The next question is, a contract of sale can be A. Absolute only, B. Conditional only, C. Absolute or conditional, or D. Conditional only with the consent of the buyer. The correct answer to this question is option C, that is absolute or conditional, which means that a contract of sale can be both an absolute one or a conditional one. The next question is, where the transfer of property in the goods is to take place at a future time or subject to some condition, then such contract is called A. An agreement to sell, B. A contract to sale, C. Future contract, or D. Conditional contract. The correct answer to this question is option E, that is an agreement to sale, which means that where a transfer of property in goods is to take place at future time or subject to some condition, then such contract is called an agreement to sell. The next question is, what are the requisites of a contract of sale? Options are A. An offer and delivery of goods, B. An offer to buy or sell goods for a price and its acceptance, C. An offer, delivery, possession and acceptance, or D. An offer, price, delivery and acceptance. The correct answer to this question is option C, that is, the requisite of a contract of sale is an offer, delivery, possession, and then acceptance. The next question is, dash is termed as a consideration in contract of sale. Fill in the blanks. The options are A. Exchange money, B. Barter money, C. Price, or D. Reward. The correct answer to this question is option C, that is, price is termed as a consideration in contract of sale. The next question is, when the buyer chooses to treat a breach of a condition as a breach of warranty, then the buyer may have which of the recourse? Options are A. Repudiate the contract, B. Reject the goods, C. Ask for indemnification, or D. Set up against the seller the breach of warranty in diminution or extinction of the price, or can sue the seller for damages. The correct answer to this question is option D, that is, set up against the seller the breach of warranty in diminution or extinction of the price, or can sue the seller for damages. The next question is, when the price is not determined in the contract or agreed between the parties, the buyer shall pay the seller what price? The options are A. A fair price, B. A reasonable price, C. The market price, or D. The average price. The correct answer to this question is option B. That means the buyer shall pay the seller a reasonable price where the price of the goods has not been determined by either of the two parties. Next question is, in case of breach of condition, the breach give rise to which of the following things? Options are A. Claim for damages, B. Rejection of goods, C. A right to repudiate the contract, or D. A right of indemnification. The correct answer to this question is option C, that is, a right to repudiate the contract takes birth in case of breach of condition. The last question is the position of the finder of the lost good is that of which of the following? Options are A. Bailee, B. Bailor, C. Creditor, or D. True owner. The correct answer to this question is option A, that is, the position of a finder of a lost good is that of a bailee.